to dismantle it.
It seems when people are very frustrated by the government that it is, in fact, this administrative state that is the focus of their ire, even if they don't understand that. And Congress willingly handing over this authority, and Congress is the Article I branch. It is supposed to be supreme. Willingly handing over its authority to these unaccountable regulatory regimes is really something that has caused a lot of problems for Americans. It was supercharged, this ability of this unconstitutional fourth branch of government to destroy Americans' lives was supercharged in part through Supreme Court jurisprudence. And what is, when people talk about the administrative state and this authority that they have that they shouldn't have, they frequently talk about Chevron deference. What is that?
Chevron deference is a term drawn from a 1984 Supreme Court ruling called Chevron versus Natural Resources Defense Council. In a nutshell, what it said is, we, the courts, will defer to a federal agency's interpretation of the laws it's charged with administering. We will defer to those. We will allow those to stand, even if it's not the best interpretation of the law. As long as it's not unreasonable, we will defer to it. And then they developed a set of loose standards to determine what a reasonable interpretation was. But even in that, it was a very deferentially applied. So basically, it's heads we win, tails you lose. The executive branch agency always won. They always won in how they interpreted the statute. So Federal Trade Commission, for example, or EPA. If there was doubt as to what clean air meant, as used in the Clean Air Act, it would always go to the government.
And so what happened this year to the Chevron deference?
In the Loper-Bright ruling, it came out about 10 days ago, the Supreme Court said no more. They said this is ridiculous. We don't. Courts have tools that they use to interpret law. We call those canons of statutory construction, different formulas. Our laws consist of words. Our words have meaning, and we have rules that judges are trained in using to figure out what they mean, where there are ambiguities in the law. And they said, there's just not a good reason for us to just defer to the government on its own interpretation when we are the interpreters. That is our job to do, and that's what we're going to do.
So does this mean the battle against the administrative state is over, and that people who care about constitutional governance won, and we can all go home now?
I'm so glad you asked that question, Molly, because the answer is emphatically no. There is a grave temptation on the part of all of us. You remember that great scene in The Lion King? Or they're saying, no king, no king. There is a grave temptation we can fall into to say, oh, Chevron's gone. That means we're all free. But that's not at all the case. Chevron is not the end. It's not even the beginning of the end. It is only the end of the beginning. And it's the end of the beginning only if we make sure that it is. In other words, we have to take the next step. All this does is it says that the administrative state, when it makes laws that can throw you in prison, laws that can get you fined, that can shut down your business, they actually define crimes all the time. If all we do is say the courts are now going to interpret whether they are correctly interpreting federal law, we haven't really gained that much. The underlying injury to the constitutional structure is the delegation in the first instance to the executive branch agency of the lawmaking power. The lawmaking power, so that the political philosophers and the legal philosophers that inspired the founding generation, including, for example, Montesquieu, they were very, very firm on this principle, which is that the lawmaking power is not something that can be delegated. The lawmaker's job, once the lawmaker is chosen to make laws, the lawmaker's job is to make law, not other lawmakers. So that's what we have to tackle next. We have to get Congress to make law and to stop delegating. Now, it's a complicated problem because, again, we're producing 100,000 pages of new law every single year. By the way, quick anecdote, and then I'll get back to the main question. A few years ago, we tried to figure out how many crimes are on the books, how many federal crimes you can commit. We asked the Congressional Research Service, whose job it is, to tell us that. It took them a while. They got back to us and they said, okay, the answer is unknown and unknowable, but it's at least 300,000. The reason it was that many, but unknown and unknowable, was because of these administratively created crimes. That's spooky. Anyway, so very complicated problem. There is an elegant, almost perfect solution that would deal with most of the problem. And it's one legislative proposal called the REINS Act. It's R-E-I-N-S, regulations from the executive in need of scrutiny. In one fell swoop, it would reinvigorate Article 1, Section 1, and Article 1, Section 7, which are the ones that tell us how you make a federal law, that only Congress can make federal law. And it says that these executive branch agency rules, the major rules imposing legal obligations on the part of the public, that are significant in the way they regulate, could take effect only after they've been enacted by Congress. If a genie appeared to me and said you can pass any bill that's been introduced in Congress in the last 15 years, it would be the REINS Act, 100 times out of 100. That would do more to reinvigorate American freedom and our constitutional form of government than anything else I can think of. And I think it needs to be item number one for the Trump administration to tackle legislatively next year.
I saw